All right. Good afternoon, everyone. Thank you for joining us today for our third session with the Retirement Reimagined series. So hopefully everybody's in the right place online and here in the room. I'm Melissa Martz. I work for the Pikes Peak Area Agency on Aging, and I am here today to welcome our partnership with Ent Federal Credit Union and Laura Straub. Uh, she she
Here.
I'm going to let her share what she does at Ent when she comes up. But just a little reminder, this is the third in the series. We have three more workshops after this. We look forward to everyone continuing on with us as we go. And a reminder too that we have our yellow book that's available both in person here in the room and of course online. And it lists all of the different services and supports that are available in the region. And we look forward to people becoming acquainted with the different things that are in that yellow book. And always you can call us with any question you have about aging and we'll be happy to answer it. And so with that, I'm going to go ahead and introduce Laura and say thank you for coming.
Yes, thank you as always for having us. I'm Laura Straub with End Credit Union. I'm a community educator, but we're happy to support these ongoing financial and all things retirement type of series. So couldn't be happier to be here today. And I get the privilege of introducing our speaker. So Sarah J. Stein is a Colorado licensed attorney that practices in the areas of wills, trusts, and estates, business, and real estate. Sarah runs SJS Law, which is a growing boutique firm based in Colorado Springs. Sarah's a Colorado native. Ooh, that's rare. I'm with you, though, with an understanding of unique needs of Coloradians as they grow their legacy. Sarah graduated from Vermont Law School, cum laude, with her Juris Doctorate and a certificate in international and comparative law, and a master's degree in environmental law and policy. Sarah is also enrolled in Boston University's Masters of Law LLM program for taxation law. Sarah seeks to provide personalized, high quality legal services to individuals of all means. Sarah believes that an attorney is only one member of a client's team, which should also include their accountant, financial advisor, and other trusted advisors. The goal is for clients to leave each meeting feeling supported and as though they can always return to ask more questions. So today we're going to have her speak on estate planning ABC. So Sarah J. Stein, you want to come on up?
Hello, thank you so much for having me. Thank you guys for coming as well. I did this presentation last year, and so I'm going to go through and give you guys a little bit of an education on estate planning in general. Hopefully, we'll talk about what a will is, what a trust is, powers of attorney, maybe touch on some long-term care. Please, 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 if you have questions, write them down. You can also submit them and we can read them if you're online. And I want to make sure that you guys feel like you spent an hour with me and that it was useful and beneficial. All right, so we want to just start by talking about some do's and don'ts of estate planning. When you start this kind of idea of what's my legacy, what does it mean, what am I leaving behind, I want everyone to sit down and kind of think through those things. We spend our whole lives, I feel like, and I'm in my 40s now. I spend my whole life kind of thinking, what is this all for? And as a parent now, that's totally kind of changed and shifted. What is this all for? And as you do your estate plan, we want to put those pieces together and really draft a comprehensive plan that takes the meaning of your life, incorporates that, and allows us to execute it after you're gone. So think about goals, establish what your goals and objectives are, brainstorm, create, think about what your legacy means to you, and then communicate it. So I want you talking to your family members. I want you talking to your financial advisors, your accountants, and your attorneys. Involve everyone in kind of crafting this idea of what your estate plan should look like and what your life means to you and what your legacy means. We want to talk about when you sit down with your financial advisor, your accountant, your attorney, we want to talk about efficient transfer and administration of your assets. We want to outline wishes, be able to write down what your wishes are, designate fiduciaries. Fiduciary is a fancy term for someone who cares for your estate or you when you're unable to. And then we want to designate beneficiaries. This is a high point that I'm going to hit on over and over and over tonight. Beneficiary designations for bank accounts, retirement accounts, life insurance policies, annuities. Those are the best and easiest means for transferring your assets. We want to set up a will or a trust. Your will and trust are great instruments and vehicles for protecting your assets. They also do a wonderful job in helping us minimize taxes, prevent the incurrence of taxes. We can use those instruments to help accomplish those goals that we set up. You want to monitor your circumstances. So clients come to me all the time. We set up a will, we set up their powers of attorney, and they ask me, well, A, can I change it? Yes, you can always change it during your life, as long as we're not doing anything that's irrevocable. And B, when should I change it? When should I come back and talk to you? If there's a death, if there's a divorce, if there's relocations, if you've had a windfall of some kind, you won the lottery, you had an insurance settlement, those are great times to come and check in. And I say every 5 years is usually a good time to kind of review. Make sure that you still want to do what you did 5 years ago. Make sure that you still want the individuals involved. Relationships change, people change, and your documents can change with you. Don't procrastinate. That's a biggie. And we all procrastinate. Guilty as charged. So schedule the meeting, review and update your plan, put it in your calendars, put it in your planners. Don't neglect to plan for potential. So we want to make sure that we're thinking through, and this is where our meeting with good, competent estate planning attorneys is helpful. We're really good at running through all of the doomsday scenarios. What happens if the person you name is incapacitated? Who do we name then? What happens if something happens to your spouse? What happens if something happens to all of your loved ones? And so we can walk through all of those and make those plans with you. What happens if you are incapacitated and you're diagnosed with a terminal illness? We can walk through that with you. What's important to you with regards to end of life decisions, and that's where that living will comes in. Don't overlook tax impacts and potential liability. And so what we're talking about there is, capital gains. What happens if we have to sell our residence before we pass away? If we have significant gains, if it's a house that you paid very little for that is worth $1 million today, which those exist, I feel like, on every street corner here in Colorado now. We may have some tax ramifications, and we may be able to plan around that and be able to set that money aside for your children by just kind of thinking that through now. And then potential liability comes up in the case of, you bought a car for your child and your name is still on that car. What happens if that child gets into an accident and they don't have good insurance limits? You could be named in a lawsuit. So we want to make sure that we're getting our names off of vehicles for kids and kind of looking at all of those possibilities for where we could potentially be sued or where our assets are at risk, and figure out ways to kind of plan around that too. And these are all things we talk about in our initial consult when you're meeting with an estate planner. So let's kind of get a summary and walk through the different documents. We're going to talk about wills. We're going to talk about trusts. We're going to talk about powers of attorney. In Colorado, we have two. We have a medical and a financial or a general. And we're going to talk about advanced directives, which are also known as a living will. So a will, what is a will? A will is a written document that specifies how your property, money, other assets should be distributed among named beneficiaries. A will also appoints an executor or a personal representative. In Colorado, we use the term personal representative. It means the exact same thing as executor. Your personal representative is responsible for collecting all of your assets, paying all of your bills, and then distributing your assets as outlined in your will. A will also allows you to name a guardian and a conservator for any minor children, or if you have incapacitated adult children, you can name successors there as well or nominate them, which would allow the court to then act. There's two primary types of wills. One is what we call a simple will, and that just means there's no trust written in. The second one is called a testamentary trust will. And that's a will that in specific circumstances, if certain contingencies are met, for example, if you're the second spouse to pass away and you have minor children, a trust would be triggered for the benefit of those children. So we can create a trust after your death or at your death with a testamentary trust will, or we can do it during your life with a revocable living trust or an irrevocable trust. And we'll talk about those more too. But those are the two primary types of wills. Your personal representative is one of the biggest decisions I think clients make when they come in and meet with us. People generally know where they want their stuff to go and who's going to inherit their assets. But when they come in, they think about, well, who should I have as personal representative? You should name someone that you trust, someone who's responsible, and someone who's really good at being neutral. Being a personal representative is not a great job. It is not an honor to do. I have so many clients that come in and they have two kids. And they think, oh, if I name Johnny, Adam's going to be so upset. His feelings are going to be so hurt. And I tell clients all the time, like, no, name the kid you like the least, because it's not a fun job. If that's the bar, it's not a fun job. It's not a privilege to have that job. It's a lot of work, takes a long time. They are allowed to be paid reasonable compensation for the time and the services they provide. So you don't need to worry about leaving someone money to be personal representative. The statute here in Colorado already covers that. Most of the time, people are naming their spouses, they're naming trusted friends or family members, or they're naming professionals. So if you don't have someone that can do the job, not a big deal. We have professional fiduciaries, either that work for banks and trust companies, or there's individuals that's their job, that's their career. They serve as powers of attorney, they serve as personal representatives and trustees. So what is a trust? And I hear this all the time. People come in and say, I want a trust. I don't want my estate to go through probate. And they don't often understand what the difference is. So a trust is a legal arrangement. It's a contract where one party, who we know as the trustor or the grantor in the document, transfers assets to another party named the trustee to hold and manage for the benefit of a third party. Trusts are often used in, financial planning arrangements, asset protection. Trusts are often used when you have individuals with special needs and disabilities. So there's lots of different uses for trusts. When do we need a trust? Actually, I'm getting ahead of myself. Types of trusts. So trusts, we have a couple of different types here. We have revocable trusts, which are trusts that you create during your lifetime. They're also known as inter vivos or rev trusts. And you can revoke them at any time during your life. It doesn't change how you control the assets. It doesn't change how the assets are taxed. Then we have irrevocable trusts. We use irrevocable trusts for asset protection, Medicaid planning, and then also revocable trusts become irrevocable, usually at the grantor or settler's death. They're taxed differently. They are also generally not controlled by the grantor. So to make an asset protection trust work or a Medicaid planning trust work, it needs to have a third-party trustee. The living trust, we kind of talked about that with the revocable. And then we talked about the testamentary trust. We also have charitable trusts. So I often have clients that are very charitable minded. I often have clients that come in that maybe they've got business assets that they're getting ready to sell that will have high tax consequences when they sell, lots of capital gains. And we can use different types of charitable trusts to leave money to charities. Some of those trusts allow the grantor to get income during their life. So they're able to kind of give the asset to a charity, but still collect the income that those assets make during their life. And then at their death, those assets transfer to the charity. Sometimes we have the reverse, where we have clients that will set up a trust and all of the income from the trust goes to the charity. And at their death, then those assets will pass to other third-party beneficiaries. So we can use trusts for charitable planning as well. Who needs a trust? Not everyone needs a trust. If trusts are not set up correctly, they create more problems and will cost you more in legal fees in the long run. There are a couple of situations, though, in our practice that we say, oh, you automatically need a trust. I've got a list here, but I'll kind of talk about the high points. One is blended families. So if we have second marriages and we've got children from prior relationships, a trust is an incredible vehicle to make sure that those children are taken care of in the event of a death of the second spouse. Passes, or in the event the first spouse passes away and the second spouse maybe remarries or something like that. It also ensures that the second spouse can't make changes that harm the first spouse who passed away's children. If there's minor children, we always need a trust. We can't give money to a minor without involving the court with a guardianship and a conservatorship. Conservatorships govern the transfer of funds to a minor. So we can avoid involving the court, we can avoid those legal fees, and we can have a lot more flexibility in how those assets are invested and managed if we use a trust and plan with a trust. Tax planning. If you have a net worth, this year it's a little over 13 million, next year it'll go up to about 15 million. If your net worth exceeds that, we would want to use a trust for some tax planning to try and cut down on estate taxes. Talked about charitable giving, or in assets and beneficiaries. If you are married to someone who is a non-US citizen, we can use trusts to make sure that they're protected in the event of your death, and that their assets are not significantly taxed. If you have an asset that you want to control from the grave, meaning, and I've got the example, we've got a ranch out on the eastern plains of Colorado that's been in the family for generations, and it grows a certain type of beef cattle. And grandfather comes in and he only wants this type of beef raised on his ranch, even long after he's gone. The only way that we can do that is if we put the ranch into a trust and put those specific terms in there. Otherwise, with a will, once you transfer the assets to the beneficiary, it's out of your control. Once that transfer occurs, the beneficiaries have it, they have complete control of the asset. This next one is if you own real estate in multiple jurisdictions. So you've got a vacation home down in Florida, or you've got ranch land in Illinois, and you also own a residence here in Colorado, we're going to have a conversation about whether you need a trust or an LLC, because real estate can only be transferred through the probate process, and every state has their own process. So if you own property in Florida, we're going to have to go down and go through a probate process in Florida to transfer that home in Florida to your kids. And once you start tallying those costs up, the costs add up quite quickly. The other side of it is too, Colorado's probate process is really not that expensive. I think right now court costs are around $250. Still have legal fees, you have to pay the lawyers or do it yourself. But that's not terrible. And the timeline, the process is no earlier than 6 months after appointment. So 6 to 18 months on average is how long the estates take to do. And that's okay, because we always have taxes to file a final tax return. And depending on when someone passes away, we can't file that final tax return for up to a year. If you pass away in January and you already had taxable income that year, we're stuck waiting until January of the next year to file that tax return. So it doesn't necessarily hurt us to have a probate estate take that long, because you're going to be sitting there waiting anyways to file that tax return. What's the difference between a will and a trust? So anything that passes in a will is subject to probate. Probate is the legal process that is overseen by the court system that allows personal representatives to be appointed, and then oversees, sort of remotely generally, the process to have those creditors paid and making sure that the assets get where they're supposed to go. Again, I just talked about Colorado's process isn't so bad. In other states like New York, California, it's very expensive, takes a very long time. In states like California, the last recommendation that I heard is that if you have assets in excess of $40,000, you should have a trust. And what you heard me say is there might be situations where I'm telling you not to have a trust if you don't have $15 million worth of assets, right? So it really is state specific. Colorado's not so bad. The last will and testament, once you draft that document, you don't have to do anything until you pass away. You die, that's the trigger. Then your personal representative does all the work. With a trust, we have to do some legwork during your life. We do some of the administration now. With a trust, the assets will avoid probate. So if your trust says, at my death, I give 50% of my estate to my son and 50% of my estate to my daughter, we can, right at your death, start making arrangements to make those distributions out without them getting held up in the process. With probate, we can't. We have to pay the creditors first before we can distribute those assets. There are other things you can do. You don't need a trust to avoid probate. So the first thing I say with married couples, when a married couple walks into my office, we are planning for the second spouse to die. Because if we have the right conversation and we take the right steps, we can use beneficiary designations and joint tenancy to pass all of the assets to the surviving spouse with no intervention. It just happens automatically. So joint tenancy is a really good option for passing assets, especially between spouses, without them getting stuck in that probate process. We can use beneficiary designations. We have a couple of different ones. We have payable on death and transfer on death. So when you go to the bank and you're talking with your banker and saying, I want to put a beneficiary designation on my checking account, they're going to ask, do you want it to be payable on death or transferable on death? Payable on death just means they will write a check for the amount that is in the account to you once you come in with the death certificate. Transfer on death says they're going to leave the account open and just put it in your name. So a little bit different, whether you get cash or just get the ownership interest in the account. And then the last option we have, which is wonderful for real estate, is beneficiary deeds. We can name a beneficiary on our real property during our life and record it with the clerk and recorder, and automatically at your death, that person will assume ownership interest. It's a great tool, but if you will need Medicaid for long-term care, it will disqualify you for eligibility. So as part of this conversation of like how, what does my legacy mean to me? Where do I want my stuff to go? We also have to take into consideration if you need long-term care, if you are unable to care for yourself in your own home, how are we going to pay for it? Do we have the means to pay for it? And that will kind of tell us whether or not we can use the beneficiary deed or not, or if we need to do some other planning. There are other options there. Started to talk a little bit about probate. So probate is the Latin term for the word prove. So the idea is that we deliver your will to the court and we are proving the validity of the will. That's where the probate process comes from. The general probate process requires your personal representative to deliver the original copy of your will to the court in the county that you live in, hopefully within 7 days. Statute says 7 days. There's no enforcement mechanism on that. So there's no penalty if it doesn't happen. But you bring it to the court and we lodge the will with the court. Then you have to fill out some paperwork and submit that to the court. File it with the probate court in the county in which you pass away. The clerks, if it's an informal petition or application, will review it and they'll look at your will and they'll say, looks consistent, looks all the same, no funny business, and they will appoint and rubber stamp your personal representative. Then they will give your personal representative a court order appointing them, but they'll give them what they call letters testamentary. Letters testamentary is I call it the hunting license for your personal representative. You carry it everywhere with you, and it allows you to step into the shoes of the decedent to marshal those assets, access all of the information they would have been able to access themselves. And so that's really what we're waiting for. Once we have letters testamentary, your personal representative can go and do everything that they need to do to close accounts, open a new estate account, make sure your house is secure, and then they start going through an inventory process. The other thing that probate does is it can take the length of time that creditors have to come forward to get paid from 12 months down to 4 months. So one of the first things we do is if we have known creditors, we send them notice and say, you've got 4 months to come forward and get paid. And then we also publish notice in a local newspaper, and that puts creditors on notice that they've got 4 months to get paid. Probate's really interesting because creditors have to file a legal claim to get paid. Just because you racked up a debt during your life does not mean a creditor will get paid at your death. They have to jump through some certain hoops, and that's really what the probate process does. So, when you have a trust, we generally still open probate because we can shorten the amount of time that creditors have to come forward to get paid out of those trust assets. The trust generally, especially if it's a living trust or a revocable trust, those assets still have to stand for the debts that you make during your life. Pros and cons. If you have a very simple estate, going through the probate process is no big deal. If you have a very complicated estate, it can hold those assets up in the distribution process. So I kind of mentioned that before. If you have a trust and your trust says, I want everything 50-50 to go to my kids, as soon as you pass away, we can start the process of making those distributions, getting those accounts organized, etc. In probate, we have to wait for that 4-month period to see if any creditors come forward, pay those creditors before the beneficiaries receive their 50-50 share. The realities of probate. So another reason we use probate creditors, well, the IRS is a creditor, right? There's nothing certain in life except for death and taxes, as the saying goes. So you need a personal representative or a trustee to file your final tax return. And we can't get a personal representative without going through the probate process. So that's reality number one. Reality number two, you need someone to pay your bills. And number three, you need a personal representative to marshal or collect all of your assets and distribute them to the heirs or the beneficiaries as you've outlined in your estate plan. Disadvantages, assets are tied up in that process. Your will becomes a part of the public record. So this can be a big deal for some people where they don't want their information out there. But just like all court records, with the exception of those surrounding minors and conservatorships, it's open to the public. So that is another area where I have some clients that are like, we just want what we're doing with our estate to be very confidential. We want to use a trust. And number three, it can take a long time, especially if there's questions, if the will isn't drafted well, if you've got beneficiaries fighting, it can take a long time. So again, trust, we can start making those distributions right away. With a will, we have to wait until we get through that process. All right, we talked kind of about the alternatives for probate. Let's talk about powers of attorney. Powers of attorney in Colorado, we have two. We have a medical power of attorney and a general durable financial power of attorney. Powers of attorney, in my opinion, are the most important document for every single person over the age of 18. So if you have high schoolers and you're listening and they're turning 18 and going to college, they need a power of attorney. The reason why is parents don't automatically have legal authority to get information or, control assets for their children once they age out. We know that. Same thing for marriages. You are not automatically entitled to get access to your spouse's information or make medical decisions and treatment or, placement decisions for them just because you're married. You have to have a power of attorney. Powers of attorney plan for incapacity, or they can also be used for convenience purposes. So I have some clients that travel quite a bit, and they've got powers of attorney structured to allow their adult children or a trusted advisor to write checks or pay bills or help file their taxes for them while they are abroad. But planning for incapacity is the most common use. If something happens to you and you're unable to speak for yourself, you've been in a car accident, you've had a head injury, you have been diagnosed with dementia, you are terminally ill, whatever the case may be, there's been an accident, car accident. We need to make sure that we've got a way for someone to step into your shoes and make decisions in your best interest to support you. So the general legal power of attorney, general financial power of attorney, allows someone to step into your shoes to make all the legal decisions you could make for yourself. So anything you can sign your name to, that's the purpose of the financial power of attorney. Medical powers of attorney allow someone to step into your shoes to make medical, treatment, and placement decisions for you. Placement means, where do you go if you can't live at home? And this can be a biggie because some clients have very different opinions about what quality of life means for them, like where they would want to live if they couldn't be at home. So you want to name individuals that will support you there. Who should be your power of attorney? For your financial power of attorney, you want someone who is meticulous with accounting, super organized, can be trusted to keep copies of invoices, pay bills on time, can be very bookkeeping and accounting minded, get your taxes filed. We don't want, your broke uncle who gives money all the way and gives unsolicited investment advice to probably be your financial power of attorney. For medical, you want someone who knows what your end of life wishes are, who agrees with you about what quality of life and end of life should look like, and someone who can honor your wishes even if it's difficult. Someone who, if you are diagnosed with a terminal illness and you have no treatment left available to you and you don't have your wishes written down, will know what to do in that circumstance. Do we leave you on life support? When do we remove those supports and allow you to pass away peacefully? Those two people could be very different people. So that's another consideration, is who do we put in each of those roles? The next document that we have are living wills or advance directives. First of all, if you don't have a living will or an advance directive, your medical power of attorney makes those decisions for you. Living wills and advance directives, they mean the same thing. So I'll call it a living will. But a living will governs two limited circumstances. The first one is you've been diagnosed with a terminal illness. You've reached the end of the line as far as treatment goes. And for whatever reason, you were unable to communicate your wishes. You could be unconscious. You could not be able to speak, whatever the case may be. And the living will asks two questions. Do you want to receive life-sustaining procedures? That could be ventilation, CPR, bypass, whatever the case may be. And the second question is, do you want to receive artificial nutrition and hydration? If the answer is yes to either of those questions, then it goes on to ask for how long, and we write that down. The second circumstance that the living will governs is a persistent vegetative state. So you are comatose with brain death as certified by two doctors. And we ask those same questions. Do you want life-sustaining procedures? If so, for how long? Do you want artificial nutrition and hydration? If so, for how long? If you don't have this document, not a big deal, but your medical power of attorney will make those decisions for you. So again, choosing someone that knows what your wishes are is really important. Having the conversation of what your wishes are is very important. Organ donations. Are you an organ donor? We want to know, and we write that into your medical power of attorney and your living will. We want to be able to give your agent under your medical power of attorney with the legal authority to make those donations should you so choose. And my associate helped me craft these, and he clearly has a sense of humor, so it's a dead giveaway. All right. The next part of this that I want to talk about is Medicaid planning and long-term care planning. So we talked a little bit about what happens if you can no longer remain in your home and you need long-term care. How do we pay for that? We have two primary options. One is long-term care insurance. Long-term care insurance, if you are between the ages of 55 and 65, 65 is pushing it, you should be investigating whether long-term care insurance makes sense for you. Talk to your financial advisor, talk to your insurance brokers. There's lots of different options out there. Some of them make sense, some of them do not. The reason that window is key is there's a threshold of how long we're paying premiums for. The earlier you get long-term care insurance, the least expensive it is. The later in life you get it, the more expensive it is. And so based on kind of when most people need long-term care, what your health history is, all of that, those are all factors to consider. If you don't have long-term care insurance, you will need to pay for it yourself. And I'd hate scaring people, but the realities of long-term care right now is that it is exorbitantly expensive. When I first started in this practice area, gosh, almost 15 years ago now, in-home care was the least expensive option. You could find aides and CNAs to come in and do 24/7 care for less than you could for institutional care. That has changed. If you would like to remain at home and you need 24/7 care, you are reasonably looking at spending $25,000 a month for that care. So most people look at going into a facility, a care facility. Care facilities, I'd say in Colorado, are on average 8 to 12,000, depending on if you're in assisted living, skilled nursing, memory care, etc. If you're in independent living, which means you can still really take care of yourself, that's much less, usually in the like $3,000 to $5,000 range. But as soon as you need help with medication, you need help with transport, bathing, any of those things, it gets very expensive very quickly. Your health insurance will not cover it. It will cover, Medicare will cover 21 days of rehab. So if you have a stroke and you have deficits on one side of your body, you will have 21 days to go to a rehab facility where they will do PT and occupational therapy to try and get you that strength back before you will have to be transferred to a long-term care facility. So this second option, you got to pay for it yourself. If you don't have the means to pay for it yourself, we have Medicaid. Medicaid is a state pay option. You have to qualify. It is an asset-based qualification program. So generally speaking, what we have to do is spend all of your assets other than your home is an exception, down to $2,500. You are also allowed to keep one vehicle if that vehicle is used to take you to medical appointments. You are allowed to keep your home as long as you can return home. So that's often a big question mark. There are clients that come in all the time that know that they're in the spend down process, but they don't want to like flush the money down the toilet. And we have some means and some planning options that we can use where we can take retirement assets, for example, and shift them on the balance sheet to assets that Medicaid will say are allowable. Usually it's using like a Medicaid-based annuity or Medicaid-approved annuity where we take a lump of cash and we put it in an annuity and we turn it into income. Because again, Medicaid is an asset-based eligibility program, not necessarily an income-based eligibility program. All right. The most important thing that you can do is have hard conversations with your loved ones. Nobody likes to talk about this stuff. I always tell people, I said it today, Thanksgiving's coming. It's a little awkward for a few minutes to hash this stuff out, and then you can enjoy the rest of Thanksgiving dinner, but it's a prime opportunity to talk to your loved ones. They need to know what your plan is. They need to know what your wishes are with regards to quality of life, end of life decision making. But you also need to know, what do they want? I can't tell you how many times people fight over stuff. And clients are always surprised when they have this conversation with their children, what they want. And it's usually never what the mom thinks the daughter wants. It's the things that have sentimental value are not the high value items. They're the things that have the most memories attached. So you need to have that conversation with them to know what their expectation is. You need to talk to your doctors. So we talked about an advance directive and a living will that governs end of life. You did not hear me say, do not resuscitate. Did not hear me say DNR. That is a medical order. That is something you have to put in place with your doctor. Your doctor also has a form called the MOST form. That form outlines what your wishes are in the event your heart stops while you are in medical care. At the bottom of that form, your doctor signs it. The same thing with a DNR, and this is usually the form that they use. So you've got to have that conversation with your doctor about what your wishes are. I had this conversation with another client today. As we age, having your heart stop and needing CPR is a very different experience than if you are 20. Because the way that they get your heart to stop or to start again is a very violent process. It is not what it looks like in the movies. My husband is a critical care nurse, and he has explained to me multiple times come home where they feel your ribs break. They feel your sternum crush. And when we're older, we don't heal like we did when we were in our 20s. So again, this goes back to quantity of life versus quality of life. What's important to you? Have that conversation with your doctor. And then have a conversation with any other beneficiaries. So if you have charities that you supported in life and you want to support in death, we need to talk to them. We need to see what their requirements are for you to leave a bequest to them at your death. So communicate with all parties. All right. We have about 10-15 minutes left. Any questions? Any questions online? I'm looking behind me because Jared is the man with the monitors and he looks online. Yeah. Okay. So the question is, if one spouse passes away, does the house go into probate? If we do our job correctly, no. So if the home is in joint tenancy with the right of survivorship, it will not go into probate. Colorado is a weird state. Every client that comes into my office, we pull the title on their home because the default in Colorado is not joint tenancy with the right of survivorship. In Colorado, you need to have the magic words joint tenancy or joint tenancy with the right of survivorship on your deed for it to be in joint tenancy. If there's 2 names on the deed or 3 names or 4 or whatever it is. If you have multiple names on a deed and we don't have the magic words, we cut it like a pie and it goes into percentages. So if you own a home, and that's called tenancy in common, if you own a home with your spouse as a tenant in common because the title company made a mistake 30 years ago, it will have to go through probate to transfer back to you. So we want to check our deeds. That's something that we do as part of our estate planning process. And if you go and see an estate planning attorney, ask them to check the language of your deed. So that's number 1. Number 2, I had clients today where one spouse owned the home and she, for whatever reason, maybe they had a marital agreement, maybe it's a second marriage, whatever the case is, she didn't want to add him on title now. So what we did then, we used the beneficiary deed so that at her death, if something happened to her, it would automatically transfer into her spouse's name if they're still married. Any other questions?
Sarah, we do have a question online. Jennifer, you should be able to unmute and ask your question.
Awesome. Hi, Sarah.
Hi.
So I have a question about the beneficiary deeds. Because Colorado, I know they protect spouses and adult children. I have a unique situation with 3 siblings. They have been in the house for 33 years. They had a beneficiary deed. The 2 older siblings have just recently been moved to placement. And the argument is that now they're trying to say that this other sibling who's in their 70s isn't entitled to the home. And I know that you mentioned that if it's a beneficiary deed and they're needing Medicaid, does that mean that the Medicaid need trumps the beneficiary deed and it needs to be sold, leaving the other older adult with nothing and then the other two covered?
Let me break it down. I'm going to ask you a couple of questions.
Yeah.
So who is on title of the house? Who owns the house?
The two older sisters that are in their 90s.
Okay. And who left the beneficiary deed?
The two older sisters left the beneficiary deed to the younger one.
Yep. So unfortunately, if the two older sisters are asking the state of Colorado to pay for long-term care, the state of Colorado will ask them to revoke the beneficiary deed in order to pay for long-term care. But there are some exceptions. So there's this idea with Medicaid that you're going to lose your house if you get Medicaid. That's not how it works. What Medicaid does is they keep a running tally of the expenses that they pay on your behalf. And it's kind of like insurance. So there's negotiated rates that they pay for each care facility based on the needs, et cetera. And then at your death, Medicaid has the right to file a claim in your probate estate to get repaid, or file a lien on your house so that when the house is sold, the proceeds from the sale of the house will go to payment of that debt. It's kind of like a mortgage, right?
Mm-hmm.
But there are some exceptions. There are, if Medicaid at their death comes with a bill, there are some exceptions. One is the house is owned in joint tenancy with other members of the family. You can usually use that, and Medicaid won't file a lien.
Okay.
If another exception is if you've got an adult child residing in the house and they cared for you. That is another exception. So there are some exceptions to the Medicaid lien process, but unfortunately, in order to apply and receive benefits, that beneficiary deed, the existence of that beneficiary deed, will preclude them from being accepted into the program. So it'll have to be revoked.
Okay, thank you.
Yeah. Any other questions? Yes, so the question is, on your powers of attorney, if you have one agent named, can you list a second so it'll automatically pass to the second? So can you have a successor? Yes. And that's what I was saying. Lawyers are really good at the doomsday scenarios. We try our best to plan for all of those worst case scenarios. And we have successors. We don't want to ever really leave you without a power of attorney. Because if you have to go to court to get a conservator appointed because you don't have a financial power of attorney, you're going to spend thousands of dollars. And a power of attorney in our office is $250. So we really try to make sure that we give you documents that are effective, that they're effective for a long time, and that we're actually going to save you money in the event of an emergency. And I don't know if I said that. If you don't have powers of attorney during your life and we need someone to step in and make those decisions for you, the only person with legal authority to give a third party the power to make decisions over you is the judge. That's the purpose of a guardianship and a conservatorship. So in the event of an emergency, if you need it, the cost to get an emergency guardianship or conservatorship is, $5,000 plus, maybe $10,000. If we've got time and we can wait the 2 to 3 months to get into court, which is usually how long it takes right now to get a hearing, you're easily spending $3,000 to $5,000 if no one's arguing. If they're arguing, we're easily into $10,000 to $20,000 or more. So get your powers of attorney done and name your successors, to your point.
And Sarah, we have a question or a hand raised from Mary online. Mary, you should be able to unmute and ask your question to Sarah.
Hi, Sarah. Thank you. A great presentation so far. So I've always heard that if you have a will, you can avoid probate. But you're telling us that it still goes to the courts and gets figured out by the courts. So I guess I'm a little confused.
Yeah.
Could you elaborate more on that?
So I think what you're hearing is if you have a trust, you can avoid probate. That's the spiel. And there are a lot of people that make a lot of money giving everyone a trust. It's like Oprah and some of these businesses. And I have financial planners that are writing clients trust that they shouldn't be doing that. They're not lawyers. But it's like you get a trust and you get a trust and you get a trust. And that's what they tell people is it will avoid probate. But what it does, if it's funded correctly and drafted correctly, the assets avoid probate. And I want to distinguish between your estate, which includes your creditors, and your assets. So if you have a properly funded and properly structured trust, your assets can avoid being held up in the probate process before being distributed.
Okay.
But I would say 90% of the time, maybe more, we are opening probate so that we can shorten the amount of time creditors have to come forward from 12 months to 4 months so we can deal with those. Or we are still going through and opening probate to get a personal representative appointed to file your final tax return.
Okay, that makes sense.
Yep. So
Thank you very much.
the will will always go through probate. If you
And the
have assets
trust,
and the trust,
you're saying that you would still open up probate to allow the shortening of the time for the creditors. And I forget what else you had said, but
yep, creditors
that
and pay
makes
taxes.
sense.
But yeah, wills
Taxes.
generally are subject to probate. Trusts are less so.
Okay, great. Thank you.
No. So that's the other. So the question is, she said, by doing that, do we still reveal all of the information in the trust if we open probate with a will when we have a trust? No, because we are not going to file the trust into the record with the court. But the will be filed into the record with the court. I'm generally not afraid of that because the will, when you have a trust, just appoints your personal representative and says all of the assets should be poured into the trust. It doesn't say what the trust says. Any other questions? Awesome. Well, thank you guys so much. Oh, we got one more. Go ahead. The question is, regarding organ donation, do you still have a body to bury? So interesting. Yes, you do generally. It's kind of like an autopsy that they go in and pull out what they use and they close you up and still give you a body or give your family a body back to bury. One thing I will say, I have some clients that have donated their body to science. And that's great. Like the universities can use it. There's research facilities that can use it, etc. You must make those arrangements during your life. This is not something you can write into your will and expect to have happen. You have to sign the contract with whatever facility you are donating to during your life while you have capacity. And then you leave the instructions to your personal representative to make it happen. Sounds good. Well, thank you guys so much. If you have any questions, feel free to reach out. You have my email address and my phone number here. And I encourage everyone to meet with an estate planning attorney. It doesn't have to be me, but meet with an estate planning attorney, have the conversation, and get your ducks in a row. Thank you.
Thank you again, Sarah. Thank you again, Ent, for this 12-year partnership that we've been doing the Retirement Reimagined. And to all of you who are online, I hope this gives you a lot of good food for thought. But we also hope that you will share with your friends or yourself, because next month or next week, September 25th, is Caregiving with Compassion. And so there are probably a few people that have been listening in for the previous sessions who might not be caregivers. We hope that you will pass this on to people that you know are caregivers, or maybe still join us next week anyway, because you never know when you might run into a caregiver and can support them better. Oftentimes, caregivers are the last people to reach out and say, to their best friend, I need help. And so it's always really informative when we can educate ourselves about how better to support caregivers. And again, for people who are online and are caregivers with us right now, we look forward to seeing you guys next week. So have a good rest of your week, and thanks for joining us. Good night.